Anytime you hear the term and try to understand trust, that's where the inquiry starts. It doesn't stop. So I'm trying to, without confusing everybody, explain more about trust. So let's dig in and let's see if I can be successful with simplifying trust. So as a caveat, you've already heard me say trust can be complicated and trust can be confusing. So I'm going to talk about the different types of trusts and what they're intended for, what is their purpose. We've talked about testamentary trusts. Those are the trusts that are in your will and that will be created upon your death through your will and through the probate process. If it's not a will created in the trust, if it's created during your lifetime, that is called a living trust. A living trust is also called an inter vivos trust. This type of trust is not in your will. It is a trust you create while you are alive, and you do it for a very intentional purpose. So a little while ago, I said that trusts can avoid probate. So a very common and probably the most well-known type of trust is what we call a revocable living trust. A revocable living trust is an estate planning document you sign while you are alive with the primary purpose likely to be, I want to avoid probate on my death. For a revocable living trust to work as it's intended, you need to make sure that you fund that trust. And this is where people run into troubles, because oftentimes people don't understand what is a trust. Trust is a legal entity you have created by signing a document. You likely, since you created it, you're called the grantor. The trustor means the same thing. You're in charge of the money, so you're the trustee. And you're the beneficiary of the trust, so you're the beneficiary. And on your death, you want to go wherever, and you say who the next beneficiary is. I think one of the reasons that there's so much confusion is like, well, it sounds like I just own this asset outright. So how is it different when it's in a trust? In fact, when it's in this kind of trust, you don't even get its own tax ID number for the trust. You use your Social Security number. You don't file a separate tax return. So it doesn't even feel like it's a legal estate planning entity separate of you. And because of that, people often forget about their trust and they don't understand how they're supposed to manage their trust so it works as intended. And when I say as intended, what I mean by that is that the assets on your death go to the next person that you want to receive the assets. In order for the trust to work as it's intended, you need to put your assets in the trust. What assets? Your house. It needs to be deeded into the name of the trust. If you own the house in your name, you need to do a deed that deeds it from yourself to yourself as trustee of your trust. You need to record that with the county. People often forget to do that. And if they don't do that, then the trust doesn't work as intended, and it will go through probate. Because if you have, you know that if you have a revocable living trust, you also have a will that's called a pour-over will. What that is that's the will that captures all the assets you forgot to put in the trust, which is common, and there's a probate to gain control of those assets when you die and put them over into the trust. So not only do you have a probate, but you have a trust administration, because the trust wasn't funded properly. Other assets that you put in the trust are your bank accounts, your investment accounts, whatever assets you own. Typically not put in the trust would be your 401k or your IRA. You need to make sure that those assets are directed to pay where you want them to pay. Having said that and highlighted the problems with a revocable living trust, they can be a great estate planning tool, but only if you understand how it works, that you properly manage and administer your trust, and you understand that you don't get any asset protections with this trust. In state of Washington and Idaho, your assets you put in this trust have no asset protection. And when you die, when these assets go, for example, to your spouse who gets your share of it. None of those assets are protected for your surviving spouse. You don't get asset protection with a revocable living trust, but you do avoid probate. An additional benefit is if you lose capacity during your lifetime, then a successor trustee manages those assets for you. That person is typically also the same person you designated under your financial durable power of attorney. So a will and a revocable living trust are the primary estate planning documents that are used for what happens upon your death.